This is a bit of an abstract topic, so some philosophy, but some take-home points at the end of it. So, is the judiciary and are the laws fair? Essentially, we are checking the validity of Article 14 of the Constitution to our medical practice. But let me give you some examples. So, 2 years ago, the usual strike after hospital violence in Mumbai, and the Chief Justice makes a oral comment, if you are scared, you can stay at home. But on the other hand, when it is a matter regarding their own security, they think differently. In fact, there was a situation when the lawyers boycotted proceedings of the Madras High Court, and the Madras High Court ordered security to be shifted from state police to CRPF. This was challenged by the state of Tamil Nadu because they felt it is an insult to them. And when the matter reached the Supreme Court, they said, forget the CRPF, we'll call the army if required. On the other hand, when there was a person who got assaulted, he was grievously injured, but he reached the hospital treatment for a couple of days where he ultimately died. So the police who initially put charges of 304B, once a person died, they changed it to 304 Section 2, which is a higher offense. But this got struck down by the court, saying that the death is not because of the assault, but because of the delay or lack in treatment. And on the other hand, there was an occasion in Pune where a person died following anaphylaxis to diclofenac, and the same section 304 Part 2, which was invoked by the police on the grounds that the doctor had not asked for history of the anaphylaxis. Fortunately, this got removed by the magistrate court, but this is just to illustrate the situation. And in the consumer forum, where following Stephen Johnson syndrome, it was held as negligence by the doctor. But of course, we gave a rebuttal saying, every drug has complications and possible anaphylaxis. So, is everyone legally guilty? So, if we think about this, topic, there are a couple of thoughts that come to my mind. So, firstly, a larger point is judiciary biased only to the doctors, or is there something more to it? And the couple of other points, which I'll just take up one by one. Now, if you look at a common example of an issue as common as free speech, abuse, parody, troll. So this is one example that has happened very recently, and you can see the three examples where the higher judiciary has given totally conflicting opinions on each occasion. And in fact, in the last two recent incidents in May and June, the person was the same Justice Banerjee, Madam Banerjee. So this is the extent of conflict that prevails within their own opinion. So this brings a question, is the state, conceptual state, is it a nanny state which believes that, the situations have to be taught and disciplined for each and every occasion? So when I came across this one write-up which mentioned about this British India Act of 1935 pre-independence. What is interesting is it is the biggest act which was ever passed in the 400-500 years of the British Parliament, and what it basically did, it framed an entire set of laws. It had everything and anything regarding administering this colony of a couple hundred of million citizens called, not citizens but slaves of a colony called India. And if you go by simple logic, it is an act that was passed with nil Indian representatives. And if you believe that, this is pre-independence, it doesn't matter, I bring your attention to this article in the Constitution which says that everything that exists before 1947 will continue to be the same unless so and so, so and so. So in principle, it still exists. And though we believe that Dr. B.R. Ambedkar is the whole and soul of the Constitution, the bureaucrat, if I may say, who actually framed this is a person from my own city of Mangalore. He was a retired judicial officer. In 1945, he had helped to frame the Constitution of Burma, and subsequently in 46, he was the one who drafted the main did the main work, and he's acknowledged even by Ambedkar as the number 2 in the list of people who mattered for the Constituent as a document. And what did he do? He basically took extracts from the US Constitution, whatever is there in Britain, and from a couple of other places, and that is how it was drafted. And unlike the US Constitution, the Indian Parliament, the Constituent Assembly, it created a document, it approved it itself. Unlike in US, where the Constituent Assembly took this document to the individual states, and it was ratified by the people whom it was meant to administer. So this has not happened in India. So this person who wrote that article asked a very interesting question. We always, so-called pride ourselves and say that, we are modeled on the British law, the British Constitution, and so on, or whatever little they have of the Constitution. So when things work so well as a society and as laws and rules and regulations in the US, which is again drafted by the British who went there in the Mayflower ship, why is it so different in India, where the state looks at us with suspicion on each and every occasion? So the difference is that in US, it is a constitution that is drafted by citizens for their own welfare. On the other hand, the Indian constitution is drafted by a set of people to administer people of their colony. This is a difference. And this, I believe, can explain the entire set of bias, if I may say, or the nanny state and the various laws that get passed. And subsequent to this, in the formative years, we were a socialist state by choice. The leaders decided at that point of time. And as part of that, the performers, perhaps they didn't get their due credit. And doctors are definitely the better part of society who perform more than the average citizen, and they give to society more than what they get back in return. And perhaps, as expected, the IMC Act of 1956, it does not have the word welfare of doctors. It is only a stick, and there is not even a trace of a carrot in it. And conflicting judgments, conflicting opinions, the bias that continues. Just as one example in Consumer Forum, a complication following a simple, not simple, but a procedure of liver biopsy done without an ultrasound. If there's a complication, there's one judgment says which is guilty, another judgment which says it is not guilty. And then something as perhaps obvious as, giving oxygen to a premature neonate. If you don't give, obviously it's a problem. If you give and something happens, again that is a problem. And these are both remarks by senior forums. And even regarding the role of an expert opinion and what is the average standard of care. So, see, though the topic is titled bias, there have been definitely landmark judgments which have helped us in due course because the parliament has failed to enact anything relevant. Then I come to the role of having finished the judiciary, the government, the legislature which passed the laws, then the forum, and finally the role of peer bodies and actually peers. So the medical councils, associations, and of course our own colleague with whom we practice. Is there a bias? And the most perhaps, so regarding the medical council as a statutory body, this is one classical example of how the yardstick keeps changing. This is a very recent incident in Delhi where a person got admitted fall at home. He had fractured both his feet and he ended up with a fracture. Consent was taken for the right foot and the surgery ended up happening on the left foot. Okay, the matter went to the State Council, Delhi Medical Council. They had a disciplinary committee. They gave an opinion. The Delhi Medical Council gave an opinion, and then the MCI gave a third opinion. All three opinions were different. Now, when we ourselves don't have a clear picture of what is the expected standard outcome, how can you expect the non-medical people to have a clear opinion about us? And perhaps, if I may say, all this ambiguity is what contributes to bias. And what is the net outcome of this entire bias, hostility, or anti-doctor environment is that we have ended up becoming a favorite whipping boy, and we have the duty of a noble profession, the liability of a business in the consumer forum, But when there is a question of rights, unfortunately, even our own colleagues don't stand up for us, forget what to talk of the rest of the society. So this is not a bias, I would call it as a hypocrisy. And even if you take perhaps the most common problem of hospital violence, and you just look at the background, so it's a scenario where the government is it's giving up its responsibility and making the doctors and the citizens fight against each other. There are no funds, there are rising expectations, the government services are poor, the private healthcare, on one hand, high standards are expected. If you don't meet those standards, you are penalized. Those standards cost, you are not allowed to charge because there is a fixed government Ayushman Bharat charges. The charges are as per socialist philosophy, but when there is a case of negligence against you, you get penalized as per market rates. So this is all how the hypocrisy plays out in even the most common problem of hospital violence. Now just further examples of bias by various authorities. So there are Supreme Court judgments, emergency treatment is mandatory, but they are totally quiet when it is a matter of unpaid bills. There is no provision for that. The second one I just mentioned. Then simple things like biomedical waste disposal. Dead bodies which are died due to open cocks, they are teeming with infection. They may be abandoned. There is no regulation to the best of my knowledge on what should be done about this, or if it is not done, who is responsible. But even a small swab, it has to be disposed. You have to take a license from the biomedical. Even a small doctor's clinic has to pay a couple of thousand a year. And again, I say PNDT Act is a classic example of the bias. There is nothing regarding, all the focus and attention is on the place where the initial step in the crime, that is the detection of the female sex happens. What about the place where the crime was originally thought in the minds of the parents? There is no focus regarding that. Then there are many other cases where this hypocrisy would be exposed. Another example is in traffic accidents with the insurance providers. So they will do a survey, they will get an approval done. The vehicle will be back on the road in a week. However, for the victim, either on the road or inside the vehicle, the treatment, especially if his identity is unknown, he is unconscious, there are no takers. So does it mean that the vehicle is more important than the victim? That is effectively what our laws seem to be conveying. And there are a couple of other examples. And then there are examples where, one statutory body, it conflicts with another judicial order. And of course, we can take this to our advantage to justify whatever stand we say. For example, in an emergency, either for giving treatment or for not giving treatment, there are these two conflicting provisions in the law. You decide what you feel is the best, and you use the law that justifies what you have done. And let them two sort it out amongst themselves. And a key point to highlight and also take home message is what precedes this bias is defamation. And now to address this entire thing, if I go back and look at, what is the political philosophy that has happened in our ancient country, two common epics, what we know, part of our culture is the Ramayana and the Mahabharata. What is the difference in the political philosophy in each of them? So, Maryada Purushottam Sri Ramchandra, he follows the rule of the law. So, his father gave an oath to his Choti Ma, and so she decided that he has to go to the forest. And he doesn't have anything to say, he quietly walks off. What does Sri Krishna do? When Draupadi's Vastraharan is happening, he has a power to stop it. He does not. He makes sure that she is not disrobed. So, this is social justice without violating the law. Whereas Prabhu Ram knows only to follow the law. On the other hand, if Sri Krishna's philosophy were to be used by Sri Ram, when he was asked to go to the forest, he could have technically created a forest in the urban landscape, identify a forest next to the the palace. I'm going to the forest, I'm not violating the law. Or he could have said, the oath was given to my father, his obligations to me do not extend to this extent. But he did not do all that. So the point to say is, when we address these healthcare policies, we have to follow the philosophy of Sri Krishna and not Sri Ramchandra. So, given these various areas where there is a bias, now as a take-home message, what is the plan of action? Where do we focus our efforts? So my take is we focus it on the weakest link. The highest is the judiciary, next is the government, then there are the consumer forums, then are our statutory medical councils, our professional associations and our own peers. The weakest is our own peer. Make sure there is no single case of jousting. Jousting is defamation, and defamation is a precursor to violence. Jousting is unacceptable. If anyone indulges in that, take him out. You take whatever meaning you want to that phrase, take it out, take it out. And if it goes to defamation at various forums, defamation, I'll just spend some more time on that to explain the various spectrum of defamation. Jousting is also defamation. And mass communication, as Chetan said very nicely, we have to go into social media and collect data because courts accept data. That instance in the Delhi where surgery on the wrong foot and the 3 conflicting opinions given by 3 professional bodies. So this is obviously unacceptable. And can you believe it? It is in the 2002 guidelines of the medical ethics. They have used this phrase mentioned, seen in the top. As per guidelines prescribed by the Medical Council of India, incompetence shall be judged as per these guidelines. Where are these guidelines? These guidelines till 2018, there was no trace of them. What do you say? What do you call this? You make a guideline, a statute defining ethics. But those actual guidelines are not there even to date. In fact, that same case which happened in Delhi, it went to the Delhi High Court in August 2018. The Delhi High Court asked the MCI lawyer, so do you have guidelines on penalizing and sentencing? He had to say no. And to date, to my best of my knowledge, there's been no update in that. So guidelines to evaluate competence, standards of training, these are the things that we have to do ourselves. Don't wait for the statutory MCI to do it as specialist associations. We have done an SOP for handling hospital violence in our own small group in Bangalore. It has helped us, it has worked well. We have shared it with others. So take initiatives on your own, don't wait for others to do it. And when it comes to, giving opinion, expert opinion or competency, there is one sort of conflict which perhaps needs to be understood. Medical training, it primes us to deliver the best. If you don't give the best, there is an impression that you are not competent. Legally, you are only supposed to give the average and you are considered competent. This point is not appreciated by medical professionals. And that is why this perhaps explains the root cause for defamation at the individual level, which is jousting. So what is this average outcome? That only the people of that particular specialty can decide. Not even the MCI. They'll ultimately appoint a committee which has people from the same specialist association. So that's why it comes to training competency, standard of care, and effectively what is not competent is incompetent. So the reference point for this average acceptable standard is what is not yet defined. This has to be done only by us. Even recent Supreme Court judgments have just reinforced this point. So to the drive home message, take home point is competency is average and not exceptional. And till these things are missing, there will always be huge variations in evaluation by these various forums and including media. And the other thing besides competence, incompetence and negligence is the concept of medical accident. This is something that has not been acknowledged by medical literature within India. So obviously it's not going to be acknowledged by the authorities. So it is something totally different from negligence or competent. This is the point to be, so whenever there is an adverse outcome, please consider the possibility of a medical accident, because if that it fits into the requirement, it may be neither competent nor incompetency or negligence. And if we are able to do this, we can change the narrative. Okay? Social media once again. For every complication, the question should change from, who is responsible for the negligence to the question should be, was there a negligence at all? And assuming negligence is actually defamation. It is not acceptable. Because if we don't do this, it is a precursor to hospital violence at the individual level and of course these various conflicting laws. And see, these are the various defamations. There are examples, social media, then by inaccurate representation by the media, by the news, legal defamation. I will call a biased act like PCP and DT as legal defamation. And of course, jousting is defamation by colleagues. I have examples of those, but I think I would skip that for paucity of time. And preventive measures is get into media, communicate, send a message. Otherwise, these are examples of death of doctors that have happened in the line of duty. And there are people who have actually instituted awards in their names so that they get the due recognition. And who is responsible for their death, it is actually legal defamation, I would say. Dr. Lakshmi Garg committed suicide when she was convicted under PCP and DT for Form F matters in Punjab. And I conclude with this point. See, this tussle is going to be ongoing. In fact, the government has and the judiciary themselves have a tussle. So where do we stand in front of that? Which is the reason I said focus our priority on the weakest link, that is our own colleagues, our associations, and perhaps go up till the statutory body. So Harish Salve, who actually fought for our Kulbhushan Jadhav in the UN Court, International Court of Justice. So regarding this tussle between executive and judiciary, he very nicely said, see, since 89 we have had weak governments, and in 91 we had the Second Judges Act where they set up the collegium system. So there is zero say literally for anyone else in appointing the higher judiciary. And this is because the executive and the elected, they withdrew, they lost their authority, and that is when the judiciary stepped in and the overreach, and they have refused to withdraw, and that's how in 2014 they called the NJSC also as unconstitutional. So once the lion is out on the streets, you cannot dictate them, whom to devour. Thank you.
Thank you, Satish ji. It was an excellent presentation. I would request at least to highlight us, because the doctors are attending the courts as an expert witness. So what are their rights and duties when they are attending as an expert witness?
I think there is one specific point I can mention is there are some states where the High Court has passed a notification. I think there is one in Punjab which specifically mentions that they should not be kept waiting. They should, because this is a common problem that's faced by many people. However, whether there is a single document which lists out all the rights and duties, I am not aware myself. But you basically need to state the facts. And as an expert witness, with reference to the point I have mentioned, the most important point I would suggest is, please understand what is the average standard of care. Because if the expert witness uses the word incompetent or negligence, see the thinking of the old-time professor, even if there is one infection in a post-op case, they will say, you are negligent, how can you do this? You don't deserve to do the next surgery, you stay out of OT for... Now, if you evaluate this legally, this is illegal, what has been done by the professor. I'm sure surgeons and colleagues who have gone through this can relate to this very easily. However, the legal standing is totally different. What is the average acceptable rate for post-operative wound infection? If it says 2%, if 2 in 100 get infected, you are an expert surgeon. In fact, if 2 in 100 even if you have more than that, but you have followed all the standard precautions that are accepted, that have been, by the norms that have been laid down, even if there is a complication, you are not negligent. This is the point that has to be understood by the medical fraternity, that negligence as seen by law is totally different from the negligence we understand colloquially when discussing in professional terms. I'll give you a more ridiculous example. last week that happened. There was a death of a patient with liver cirrhosis, cancer and all, and the patient's family alleged that he was given some antifungal injection at the end, after which he died. So they asked for documents. Because of some miscommunication, there was a CPR feedback form. What better you could have done? Okay, it says the ECG leads could have been connected 2 minutes earlier. The injection, adrenaline, it was given through a vein which was not really patent. All these things were mentioned in the feedback form. And can you imagine, this form was given to the patient attenders along with the case sheets? So without realizing, these are the things that keep happening.
Thank you. Any questions?
Thank you so much, Honorable Speaker, Dr. Satish Bhatt, and respected Chairperson.